Okay, just real quick, my name's Edwin Bird, and I have been doing law enforcement defense work for the past 30 years or so. Seriously, that's a long time. So I've got plenty of stories. I can sit up here and tell stories the whole time. I do a lot of work for different law enforcement agencies, including the Sheriff's Office, and I do a lot of the City of Shreveport police stuff for that period of time. So I've pretty much seen most everything and tried lots of cases. If y'all haven't been sued yet, you're going to be sued, I guess, is the place to start. And so what this little presentation is really designed to do to help you understand a little bit about what's involved, what to expect, what defenses there are, and what can you do to lessen the chance of having a big problem. The basic concept is called qualified immunity. Everybody's heard that. Most people don't really know what it is. Essentially, it's a way for officers who have done something to cause a constitutional violation to get excused from that because it's excusable. And it's a basic legal concept that courts have developed that recognize that law enforcement are making quick decisions in pretty complicated stuff. Lots of times it's fast-moving circumstances. You don't have a law library in the car with you, or you don't have a law library wherever you're working, and you don't have a lawyer with you. And so that's kind of the basic concept is, yeah, a constitutional violation has happened, but you get a defense to that. You're not going to be responsible for it. We've got a little PowerPoint. I'm not going to use much of it, but there were a few slides I wanted to run through. Hang on a second. And if anybody has a question during this, which is kind of informal, really. We usually do this for a couple of hours. This is 20 or 30 minutes, so I'm kind of free-forming here.
It might make the screen more visible if you turned a few of the lights off. Not a lot of them, but just a little bit, maybe in the back. Thank you.
This is kind of an outline of where we're going to go, talking about the types of immunity there are under state and federal law. Absolute immunity is something that's different than qualified immunity. Unfortunately, y'all don't get absolute immunity. Absolute immunity is for the prosecutor and for the judge. They can't be sued, so they've got it a little bit better than us. This is qualified immunity, the basic concept. And what we're talking about here is you'll hear, if you get sued, you're going to hear about it. It's called 1983. It's the statute. It doesn't mean the year. It was the Civil Rights Act of 1872, I think. And it was the Ku Klux Klan Act, they also called it. But it was a way for local people to sue law enforcement in Reconstruction when they weren't doing what they were supposed to be doing for whatever reason. And so this statute was passed so that people who were injured could sue local law enforcement. And then they eventually came up with this defense, which is critical to it. Hang on, let me get you. Yeah, this is the two concepts. The violation of a constitutional right and I can't read it from here. Yeah, action of an officer that's objectively unreasonable. This little concept applies in every kind of setting, every kind of constitutional violation. And I wanted to walk through just a few examples for you. So the issue is first, is there a constitutional violation? And if there is, can they sue the officer involved or the deputy involved? Typically, you'll have, it's going to be a wrongful arrest setting, a search, or a use of force would be the primary places. We see these in the police setting. In the corrections setting, it's going to be use of force, a lot of failure to give medication or medical problems. But the concept is the same. They first look and see, is there a constitutional violation? So let me give you a few examples and then we'll go through them a little more detail. A wrongful arrest claim would be an arrest without probable cause. So An example would be, I'm trying to think of a good one. This was one that I had personally that is a kind of an example of how it works. There was a preacher that was like a street preacher, okay? And he's got a First Amendment right to do what he's doing. He's downtown Shreveport yelling at people going into the casino, something to the effect of, you can't spell casino without sin, is kind of what I remember. And so the casino calls the police and says, he's on my property, I need him off. The officer shows up and talks to the manager of the casino and he says, yeah, that's our property, he's standing there, he has to be on a public place, and that's not public. And so the officer, all he did was tell him, you can't preach there, you have to move down here where it's public property. So the guy goes off. Of course, he files suit later because we wouldn't let him preach where he wanted. Well, it turns out that spot was not private property, it was public property. It was part of the easement of the city of Shreveport. So yes, there was a constitutional violation. That was a First Amendment violation to keep somebody from preaching on public property. Well, so they sued the city of Shreveport and they sued the officer. They're not trying to get much money, but they're trying to make a point out of it. And so the analysis would be, number one, is there a violation of constitutional right? Yeah, you can't prevent somebody from exercising their First Amendment rights in that setting. Well, number two, is that officer objectively unreasonable in doing that, or is he going to get the defense? Of course, he gets the defense. He's not a surveyor. He's not, he has a reliable informant telling him this is casino property. So that would be an example of qualified immunity applied to a wrongful arrest case. Another a typical arrest kind of deal is if you get sued for an arrest, we'll go through with you first and try to figure out, is there some other crime that you did have probable cause for? So even though you arrest somebody for some statute, there may be another crime out there that you don't even know exists. And as long as you have the factual basis to have charged them with that, then we get to use that. There was one I had way back where the officer used the interference with an officer statute back in the old version of it, where you had to be seizing property, serving process, or making an arrest, and it didn't fit that. It was an old lady who was giving everybody trouble at the scene of an accident, and she had a little poodle with her, and she was just being crazy acting, and she wouldn't get back away from the scene, and so he ended up having to arrest her and did a little armbar takedown of her and this puppy.
The puppy too?
The puppy broke some teeth, which was another part of the claim. It was a property damage claim. But anyway, that was a serious claim if he didn't have probable cause. She was elderly and it just had a bad smell to it. Well, turns out the interference didn't apply because under that statute, he wasn't doing one of those enumerated things. They've since fixed that. But in looking at his report, he had documented that she was so loud that the paramedic said, "Can you get her to shut up? I can't hear what I'm doing." He wrote that in his report. Well, there's a misdemeanor offense, interference with a paramedic. He didn't even know that statute existed. He gets qualified immunity because there really was probable cause and a reasonable officer could have charged her with that. So those are kind of examples of the two steps you have to do. Same with a search. If you go to the wrong place, you got the wrong house, but it looks like the right house, that would be one the court looks at and says, is that objectively unreasonable for an officer to have thought that 412 and a half is the same as 412? And so you typically would get qualified immunity there. The most common one we see is going to be use of force cases. And that's going to primarily be the objectively unreasonable part of it. So if somebody has a pre-existing medical problem, for example, and an arrest causes them to have more injury, we typically would see it with something wrong with their wrists, or something wrong with their shoulder. And so they do suffer injury as the result of some use of force. Is it unconstitutional to injure somebody's shoulder during arrest under the Fourth Amendment? Could be. But the issue that gets the officer out is number two. Would a reasonable officer have believed that this was going to hurt the person? And so, of course, it did. The key there is, did that person tell the officer in advance, hey, watch out, I got a bad shoulder, or you put my hands all the way behind, you got to use 2 cuffs, or whatever it is. And if the officer isn't given that information, then he's going to get qualified immunity. So every one of the cases that officers are sued, this is the drill we go through. And the officer typically is going to get immunity if they have documented what happened, if they can demonstrate that there was a law enforcement reason for whatever they did. If they can't, then that's when you have a problem. And so I always tell officers that whatever factual scenario it is, you probably could articulate a reasonable reason for you doing whatever you did. And if so, then you're going to get qualified immunity. That makes the documentation so much more important than it would be in an ordinary setting. The guy with the paramedic case, well, that suit was filed a year later, and by the time he got served, it was another 3 months. 15 months later, we're sitting down to talk for the first time. He had documented that in there about the paramedic. Had he not, then I never would have come up with that one. He never would have remembered those details. So that's a good example of, you got to document exactly what happened. Same goes with the officer in the First Amendment deal. He documented exactly who told him what, why he had that belief that it was private property, and because of that, he was able to get qualified immunity. The use of force setting, typically it's going to be, anytime there's a lethal force, there's going to be an analysis of the objective reasonableness of it. Any of the more controversial shootings in the past 20 years I've probably handled. And every one, that's the drill, is we got to educate the court. What was the reason for this? What was the reason for us to believe it? So it's not going to be a suit for a lethal force unless there's a problem with it. And it's a problem that, there was no probable cause to believe that, as it turns out, this person was unarmed. We'll take that as an example. The person was unarmed, yet lethal force was used. That's a constitutional violation. That's the Fourth Amendment. That's part one. Well, then you go to part two and say, well, was it objectively reasonable for that officer to have held that belief? And that's the qualified immunity analysis. So almost any of the shooting cases throughout the country that we've been seeing, that's the drill that some court is doing. And they're looking at it. The cell phone case we had in Shreveport was one. That's what the court was looking at, if you remember that one about 10 years ago. Was it reasonable? Was it objectively reasonable for the officer to have believed it was a gun as opposed to a cell phone? And if there's no factual dispute about that, then they're going to give them exercise their immunity. I guess the crux of it is, there's millions of examples that we could give you of settings where there was a mistake made by the officer, but the officer was able to defend that mistake. And the way they defend that mistake is by being truthful about what happened. When you sit down with a lawyer after you've been sued, they're going to tell you, hey, be truthful with me, and it's going to stay in the room. I can't tell you how many times the officers are very reluctant to do that. They don't really know, and they think this is part of the setup, and that it's really internal affairs or somebody's going to do something. But the lawyer who's going to be defending you has an ethical obligation to you. And if that lawyer is representing you and the entity, the sheriff's office or whatever it is, and there develops a conflict between the two, he can't dump on you. He's ethically obligated to stick with you or get out. And so that's why it's really important. Qualified immunity is the really important reason for documenting what happened exactly and as detailed as you can. And most of these things, you're going to spot the issue in advance, like, oh shit, this thing's going to end up in something. And so you'll remember to do that. The hard ones are when you don't even spot the issue, and so it's like a terribly routine deal. yet you don't have documentation. A good example of that was literally another casino case I had where it's a drunk being arrested. During the cuffing, he falls down on the ground. No big deal. The officer wrote down that he was arrested, didn't even talk about the use of force. He was handcuffed and the guy fell down and he picked him back up. Well, it turned out it's a freak deal, but where he hit on the bottom of his ribs caused pressure. It's kind of like if you have a car wreck and your steering wheel hits the bottom of your ribs. The paramedics know what that could do. It lacerates the bladder or the kidney and the spleen and all kinds of crazy stuff. Well, this guy ended up with a lacerated bladder, a lacerated spleen, and all kinds of terrible things. Officer gets sued. 15 months later, I sat down with him and asked him, do you remember this? Did you arrest a drunk at the casino 15 months ago? And of course, he said, hell, there's dozens of those, or hundreds of them. That was his main off-duty job. And he had literally no memory of this deal at all. He couldn't tell me a thing about it. And so here we were faced with a drunk who was given his version of it that was a hell of a lot different than what really happened. So that's kind of the scary place to be if you're trying to use the defense of qualified immunity. Luckily, there was a witness who was able to provide good details and had a good memory of it, who didn't arrest drunk people all the time, so this was pretty memorable to her. And so we were able to fill in the blanks, and he ended up getting qualified immunity that, a reasonable officer wouldn't have believed that this guy was hurt because it was a failure to give medical attention also. So those are examples of the two-part step to qualified immunity, and primarily with young officers in academies, I like to make them realize that if you're honest with what happened, document it correctly, then the lawyer is going to probably be able to help you and get you off of the thing. And that's immunity, not just from a judgment, a money judgment, but it's an immunity from the lawsuit. So if we get to get out early, you can go to the Fifth Circuit Court of Appeal before you even have to answer the suit. And so we do that all the time. We were looking for a case that is a recently decided case that might have been interesting to y'all. There was one, let me see where. Glenn Langley made this outline. Let me see where he put it. Oh, it's not far after that one. Yeah, this was a recent case that was just it was July, that I liked it when it came out because I faced the same deal. It was essentially a traffic stop that had gotten into a pursuit, get the guys out, getting them on the ground. One officer runs up there to him with his firearm in his hand. He doesn't holster it before he starts grabbing him. So he's got the gun in one hand and he's grabbing him with the other hand and ends up shooting him in the back. Of course, it was an accident. He documented it correctly that it was an accident and didn't try to make it into something else. And the court said, yeah, you have qualified immunity under those circumstances. It was just a good faith mistake. It wasn't an intentional violation of his constitutional rights. There really wasn't even a constitutional violation because he didn't intend it. Honestly, I've had cases where I always suspected that maybe it was an accident and the officer was afraid to admit that. I just had a hunch a couple of times on some of these. You're in a struggle and the gun goes off and it's tempting, I'm sure, for the officer to say, yeah, he was going for my gun or whatever. I haven't experienced that, but I can always sense that may be what the jury is thinking. This case is a good example of if that happened and you made a mistake, you just have to be truthful about it, and you're not going to be able to be sued for a constitutional violation. You're going to get immunity from that because we'll be able to explain what happened. And I guess that's the other point I like to make in these cases. This little discussion is, yeah, you document truthfully what happened, but you're also should be safe and comfortable in realizing that mistakes happen and you don't have to panic. There was a case I had way back where a jailer in another facility asked someone if they were suicidal. The person said yes. And she said, okay, well, now we're going to go through all this stuff. And she was like, wait, no, I'm not. And the person, she got her supervisor involved and said, what do we do? They decided just to get her on a little more watch than they normally would, but not the full-blown suicide precautions. Well, she ended up successfully committing suicide. The jailer was panicked about it and took out liquid paper and whited out the record to say no instead of whatever she had originally. We were able to fix it because we had testimony about what really happened. She had talked to the supervisor and he had documented it better. But it was kind of a painful place for her to be. It made it a hell of a lot more complicated to defend because the issue was, would a reasonable jailer presented with that circumstance had communicated with a supervisor who told her to go ahead and do it, would she be entitled to qualified immunity? Was it a constitutional violation? Maybe. But was it clearly established as being unlawful for her to do it? Was it objectively unreasonable? Could no officer have made that mistake? Of course they could. So she ended up getting qualified immunity, but not, it was a terribly painful route to get there. Does that make sense? So had she been more detailed and accurate in what happened, and she didn't lie or anything, but it made it, a little more suspect because she had tried to make it more correct as to what exactly had happened by using liquid paper, and that wasn't the right thing to do. Had she understood qualified immunity, she would have known that you could just explain that to a court, and we usually do it with an affidavit, then she's going to get the defense. Now, this doesn't mean that you have like carte blanche to do whatever you want to do. These are cases, they used to call it good faith immunity, and it's essentially that, but they're not looking at your intent. But it's like honest mistakes may happen because nobody can know the answer to all the stuff that everybody gets. The same goes in the correction setting when there's inmates with some medical problem that you don't understand to be whatever it ended up being. That's the same analysis. Should you have known that this person was having whatever medical problem it was, you'll look at number one, is it a constitutional violation? Could be. But number two, if it is, then is it objectively unreasonable for this officer to have believed, or this corrections officer to have believed that this was not a seizure that he was having or whatever. So I guess that's my kind of abbreviated version of this. I want you to take away from it that the defense is still there. We hear a lot about it. There was a bunch of cases last year that went to the Supreme Court together as a group that the court was considering whether to revisit qualified immunity. And then all the police activity that's happened, all the controversy over the last 6 months or so has made it kind of more significant. They ended up not hearing the cases. Essentially, there were several dog bite cases where almost identical things happened, and different courts throughout the country had treated them differently as to what was clearly established law regarding what you could do with a dog. One was the guy was laying on the ground under a car with his hands at his side. Could you deploy? There was one where his hands were up, but he was on the ground. There was one where he was sitting in a chair with his hands at his side. There was one where he's sitting in a chair with his hands in his pockets. All those factual scenarios, and the court was looking at every one to say, would a reasonable officer have known that it was clearly established and illegal not to do this or to do this? And so we kind of expected the court was going to revisit it because of that, but they ended up not hearing the cases, but they'll come back around. So at least when you hear it on the news, you'll know what they're talking about. Qualified immunity, the public thinks it's just the ticket to just abuse people, but it's really not. I mean, it's in its pure form, it's supposed to provide a defense where a reasonable officer wouldn't have known better. And that's kind of boil it down to the essence of it. So anyway, that's kind of my presentation. There's not been a big change in that law, but it's important to know what it is and to know why it's so important to officers. If it wasn't there, it's going to be a lot more complicated. And it's going to be a lot more expensive for the defensive officers because it's the primary issue in about 75% of the lawsuits in federal court anyway. And I'd love to answer any questions anybody had. No?
Thank you, Edwin, very much. Let's give him a round of applause, Edwin Bird. Thank you. Thank you for your help, sir. Appreciate it. Hand me that mic, if you will, there. There you go. Thank you, sir. You can go down that way. Be careful. Thank you. We'll see you Thursday. Right now, we'll see you tomorrow. When do you come back?
I'll be back Thursday.
Thursday, okay. So it's really out tomorrow. Okay, here's this. We need, okay, good. Who's got the clicker? Got it. While we're waiting, it's important to note that, thank you, sir, appreciate it. This is Don Burling's 55th year with the Bossier SO. Could you stand up, Don, please? Let's give him a round of applause. It's like every agency needs a really old fart, and it's like, I'm so glad to see you back there. How you doing, sir? All right, turn to page 100 real quickly, please. Please be nice. I got this. I think I'm all right. On page 100, the bottom third of the page, that was a statute that Edwin Bird was talking about, resisting an officer. Until 2006, you only could get to that statute 3 ways: making a lawful arrest, making a seizure of property, executing any order of the court. Since 2006, it also applies to a lawful detention. If you got 25 or 30% criminality, you can lawfully detain somebody briefly. Got to have PC to make an arrest. If you have lawful detention, then no one can resist you, interfere with you, oppose you, or obstruct you. Let's look at the very bottom of the page there. One of the things is flight. That flight from an officer is when somebody runs from you on the hind legs usually. You're under arrest, but he gets away from you. That's called resisting by flight. You don't need to mix that up with the next statute, which is flight from an officer. But anyway, A, B, C, D, E. The 5th line from the bottom is flight from an officer. That's someone who's told they're under arrest, but he runs away before he can be caught. Number 2, the guy's arrested, but he commits violence on the arresting officer before the jail. Number 3, it's the top of page 101. This is probably the one you need to mark. If you have somebody lawfully detained, which requires reasonable suspicion of criminal activity, the guy owes you his name. He owes you the name for safety reasons. That's Hibble versus Nevada in 2004. And what that means is, if you have reasonable suspicion of criminal activity and he's lawfully detained, you need to get his name. Now, your first question ought to be, is this somebody like on the street corner? He doesn't have to show me anything, but your first question ought to be, could I please see some ID? Hello, I'm Officer Smith with the Bossier SO. Good to see you tonight. Could I see some ID, please? Then he shows you the ID, now you got his date of birth, driver's license number, you got something to run through the computer. If he says, I don't need to show you anything, he's right, he doesn't. Sir, you're lawfully detained, though, but you got to give me your name. Since you're lawfully detained, I need to make sure I'm not in danger, so you're not in danger. I need your name. So you've got 3 chances with that. Under the resistance statute, assuming you start off with a lawful detention, he's got to give his name because you need something to run through the computer. You need to know whether you're dealing with Elmer Fudd or Yosemite Sam or Son of Sam. You need to make sure who this guy is. Now, the further you go on this, I think you give him 3 chances. The first one says, can I see some ID, please? Very nonchalant. No. Well, I need your name. No. Sir, you're lawfully detained. You need to give me your full name or you can be arrested for resisting an officer. Okay, I don't think you need to arrest the guy, but it triggers your PC to make an arrest. So what can you do? Instant to the arrest. Now, and starting in the same year, 2006, 26 years after Rawlins versus Kentucky. Now in Louisiana, you can search him instant to an arrest before you arrest him, or without arresting him. You can either make the arrest and the SITA can be interchangeable. Doesn't matter. And it's like if you search it, don't find anything, it'd be have a nice day. But you search it, and you find the heroin, you need to make the arrest for possession of heroin and the resisting an officer. Because the criminal defense lawyers will know, you the guy who searched my client? Yeah. Well, why'd you search him? I had the right to search him instant arrest. For what? Resisting an officer. He was lawfully detained, he wouldn't identify himself. Well, where's the arrest for resisting an officer? It's a credibility issue. Some judges don't understand, and some juries don't understand. It's going to come out to be the problem at the motion to suppress. Like if you have a new judge that's never handling the criminal cases, that's going to seem strange to him that you're searching instant arrest that never occurred. So if you got PC to make an arrest for a crime that allows an arrest, search it, see what you find, and then decide if you want to arrest him or not. It's strictly your call. Okay, real quickly. Okay, I'm going, sorry. Time is of the essence here. On chapter 1, Tammy Jump is the first assistant DA from the second JDC. You probably ought to mark pages 7, 8, 9, some stuff about report writing and stuff about appearance in court. Solid goal. And chapter 2 is title 14. And we put in this book, trying to keep the price down, we put in the book the portions of title 14 we think you're going to use. 2/3 of title 14 you'll never use, ever use. And if you have that situation, you can go to our website and we got it on there. And all you got to do is at the bottom of page 5, it tells you how to get there. You go to our little Drew Law books, free of charge, hit link to title 14, click, Control F, box comes down, you type in the words you're looking for, enter, and there's your statute. So the instructions on the bottom of page 5, if I can do it, you can do it. And it'll pop up immediately. You're looking for something like the word consanguinity, which means blood kinship. You type that in the box and go enter, and then you go right there at crime against nature. So you can find anything there. And like we used to have 21 versions of, there still are 21 versions of serious bodily injury in Title 14. You keep hitting enter, you'll go to every one that utilizes that phrase, serious bodily injury. But the only definition for that is at the bottom of page 17, section 2C, at the bottom of that page. It says for everything in Title 14, anytime you see the phrase serious bodily injury, it's got a statutory meaning. The statutory meaning will always be at least C5, extreme pain, disfigurement, impairment or loss of an organ or mental faculty, unconsciousness, a near-death experience, the loss of use of an organ or extreme pain, unconsciousness, yeah. Any of those 5. Now there is this, you will see that on our website, all the new stuff in 2020 shaded green. We're very artistic here. We alternate shaded in yellow one year, shaded in green the next. So if you go to our website and go to that link on Title 14, the new stuff in this year will jump off the pages because it's shaded in green. In chapter 3, we did it differently. We said, what are the most common questions we're getting for Title 32? And we've answered them. And I've got one thing I want to show you. Please go to page 121. And we got 10 or 12 questions about Title 32 that come up all the time. This question, about 8 lines down from the top of page 121, comes in on email or phone call once a week. If I'm lying, I'm dying. We get a question a week about this. The answer's simple, but to explain the answer took us 3 pages. There's not a really direct Louisiana Supreme Court case on this, but here's the bottom line. Look at the big hole, water is still open. If you have a lawful detention, of a motor vehicle, personal vehicle on a traffic stop, everybody in that personal vehicle has the same exact status as the driver. Good traffic stop, every swinging person in the car is lawfully detained. Bad traffic stop, everybody in the car is illegally detained. So, it ain't hard to make a traffic stop this day and age. You see an infraction, you got a traffic stop. You're not sure you got enough to stop somebody in a vehicle, well, follow them 2 blocks and then make a list of the main traffic infractions you saw. If you saw a traffic violation, you've got the basis for a good stop. You bought yourself 12, 15 minutes with that guy, however long it takes you to complete the stop. But the difference now and 20 years ago, easy to make the stop, really hard to justify extensions. It's turned around completely. Back 20 years ago, more difficult to make stops, but easy to extend. Now, easy to make a stop, but really hard to extend. So the deal is, if it's a lawful stop of the motor vehicle, during the stop, during the processing of the infraction, yes, you have the right to name everybody in the car. But the problem is, the moment that that traffic stop ends, your hold on any of the people in the car ends, unless additional reasonable suspicion of criminal activity is developed. So, the answer is yes. But to answer that, Gene and I, it's 3 pages and it's 3 pages to give you the cases and work it up to there. And actually what we're doing on this, hoping some prosecutor somewhere, when there's a motion to suppress about this, maybe they'll use this data here to help explain why it's lawful. But you need to know a simple answer, yes, is correct. During the stop, you got to write everybody's name. But the moment the stop ends, if you don't have anything on anybody else, nothing else has come up to lead you to think you've got additional reasons of suspicion of criminal activity, you don't have the right to the name, then it's adios. Have a nice day. Come back and see us soon. Also, if you look on page, also Title 32, the number 2 on the hit parade is page 124, that question 6 about recent implied consent legislation. And of course, the main thing is year before last, Katie Bugg's law that came in a Bossier case. And Judge Cox, I'm going to tell you about that. There's chapter we're most proud of is search and seizure, chapter 4. I can tell you with assurance right now, with a pure heart and a sort of clear mind, everything you're going to need this year about search and seizure, anything about the 4th Amendment in Louisiana, is in that short chapter 4 right there. We poop it all out, and we give you the cases in each category chronologically, what case started at, way to proceed, and what is the most recent case. Primarily Louisiana Supreme Court and U.S. Supreme Court cases. So on chapter 4, that's the 4th Amendment. And if you get a little bit of time to yourself, I hope you would read that, our answer to, start on page 121 about getting the names of the guest basket, and read this search and seizure chapter when you get a chance. Chapter 5 is custodial interrogation and the right to counsel, and the domestic violence. Tammy's going to go over that, and just add the civil liability. Y'all not on the sentencing end of this deal, y'all on the front end. So usually, not always, usually, we can give you abbreviations for the sentences. We can tell you what category it's in. If you see sentence colon M, it tells you it's a misdemeanor. And Judge Narron can hear it in 20 minutes on a Tuesday afternoon. If you see RF, that's a readily felony. Don't know where this terminology came from, but it's all over the state. What that means is with or without hard labor. It means he's got a right to a 6-person jury. And the real MFs are facing MF, mandatory felony. That means it's got to be a 12-person jury. Any sentence has to be in hard labor. So misdemeanor, that's M. With or without hard labor, that's RF, relative felony. If it's a relative felony type case, say like one of the thefts, and the judge gives a sentence of 90 days in jail, the guy's still been convicted of a felony. What matters is the exposure, not what the actual jail term turned out to be. So RF means it's with or without hard labor. MF means it's got to be a hard labor sentence. In the book, we underline the new statutes, mainly entitled, in chapter 2, and then we boldface and italicize the cases. We put in boldface our comments, the names of statutes, and the terminology that's being defined. The biggest deal from last year was there were 21 crimes that involved serious bodily injury. Serious bodily injury is defined in the statute. If a term is defined in Title 14, you got to check every box. But that's the only way you can prove it. It isn't like, oh man, he was hurt bad. That doesn't get it. You got to prove extreme pain, disfigurement, impairment, loss of an organ, unconscious, or near-death experience. So now, the trouble was it was defined differently in different statutes. You'd have to go to all 21 statutes, look at the C part or the D part, for this statute to see how the term is defined. Well, all the terms, all the crimes in Title 14 utilizing serious bodily injury is defined like those 5 ways there. Plus there's one statute that gives you another way to prove it. And what serious bodily injury will do, it'll move a misdemeanor to a 5-year or 8-year felony. Simple battery, 6 months jail sentence. Secondary battery, intentional infliction of serious bodily injury goes up to 8 years. serious bodily injury is a big deal. You can't just prove it by showing there was a general, he was hurt pretty bad. You got to cross the T on one of these 5 ways to define it. There's also a 6th way under the child abuse. The welfare lady's already had another definition for serious bodily injury, so we got Representative McMahon to help us with this, and we left this one in there. If it's abuse of children, one of the ways you prove serious bodily injury is malnutrition or starvation. Serious bodily injury in Title 32, for instance, we tried to change that, but we missed. You're going to have to, in Title 32, look it up. If drag racing says it becomes a felony on serious bodily injury, you go down to the C part or the D part of that statute, and it'll say, for purposes of this statute, comma, quote, serious bodily injury, unquote, shall be defined as. It makes it a felony, but only gives you 4 ways to prove it. Leaves out extreme pain. What about implied consent? On implied consent, it only gives you 4 ways to prove serious bodily injury. It leaves out extreme pain. So we got this uncertainty out there in the other statutes. Title 14 is defined one way for all 21 statutes. And then there's a 6th way for abuse of children. They had a couple of upsetting deals in the state recently, and it's like sometimes, I mean, we've got a dysfunctional family, Gene, you know that. My daughter Georgia, when she was in, say, 3 and a half, she become one of the first phrases she could ever say. It wasn't mama or daddy, it was true crime. Anyway, when she was 3 or 4 years old, she'll come running in, Daddy, true crime. I said, I wish at least she called me Daddy, that's nice. Anyway, there's too much true crime on their TV, and in some countries, you can put them in a cage, and you've got a certain amount of time to develop probable cause. Give me a break. You can't do that in Louisiana. You're going to put them in jail, you need to already have probable cause. Either an arrest warrant or you develop with your knowledge, training, experience, and your observation, what you see, smell, taste, hear, feel. Do you have enough to develop probable cause? Now, there are things that you have to do, particularly if it's a warrantless arrest, but to actually incarcerate them, you've got to make a decision that you already have the probable cause. There is no such thing as saying we can put something's not right about this lady. She's walking on foot, and there was a DA that took part, some interrogation in a jail cell. They didn't have any probable cause. They were trying to develop it, that is, get a confession. It's like you don't put them in jail unless you already have PC. But here's what's triggered when you have that. This has been in the law forever. It's for any arrest. Somebody gets put in jail and don't bond out immediately. Within 72 hours, they've got a right to speak to a judge. And it can be electronically or in court, anyway, and it's a conversation. And what it is the judge generally, in St. John Parish, what they say by teaching a bunch of places, it ain't always the same. In St. John Parish, what they do is electronically, they line up all 12 people who were arrested this weekend and said, you got the public defender, you got the public defender, they don't say anything to the public defender. It seems sort of a waste of time because some of them can afford a lawyer. But up here, generally, the judge say, sir, you got a tentative charge of first-degree robbery. I know you're still in jail after 2 days. Are you able to make a bond? No, sir. Do you have funds by which to hire a lawyer? No, sir. Okay, we'll appoint you one, please. Refer you to the public defender. You remain in jail, they'll come up there to see you. As soon as you make a bond, you need to go to their office. That boom you just heard is the Sixth Amendment coming into play. The Sixth Amendment will never come into play before the arrest has happened and the person is brought before the majesty of the court. And the real person know I'm in trouble. I'm facing significant deprivation of my liberty. I've been arrested now for 2 days. I have the right under the Sixth Amendment to the assistance of counsel. The lawyer that's appointed there is appointed for every action of any consequence in that one case. So if somebody's appointed a Sixth Amendment right to a lawyer on one case, you can still approach him on another case. But that lawyer that's appointed for that first-degree robbery will be available to him at every stage of things that happen: a lineup, a motion to suppress, arraignment, trial, sentencing, everything for that one crime right there. But you already have probable cause when you made this arrest. But the Sixth Amendment comes into play at what we call up here generally a 72-hour hearing. Then this 48-hour deal, here's how it worked. In a case called the McLaughlin case 30 years ago, the U.S. Supreme Court said there's nothing wrong with a law enforcement officer making a warrantless arrest, with a whistle. And if you arrest somebody based on your knowledge, training, experience, and your observation, it's perfectly good to go. But there's a flat 48 hours that's got to run before and a judge has to concur when you're finding a probable cause, or the guy's going to be released. And that paperwork, you can't wait 48 hours to get it to the judge's office because maybe he's gone that day. You need to have PC in your head and in your heart when you put the guy in there. You need to make that 48-hour report. Now, the sheriff can appoint one deputy per shift per office location, and chief of police can appoint every officer as an ex officio notary. So it ought not be that hard to get a notarized affidavit. Then you scan it to the judge's office or fax it to the judge's office or get it there one way or the other. Arresting officers, most of the arrests are without a warrant. If you're the jailer, you need to try to get that arresting officer to stay here and do out the affidavit now, because it's going to be hard to find him tomorrow in the 48 hours of running here. But this is not for just is there probable cause. It's does the court concur with your decision to find probable cause. But in neither one of these scenarios, the 48-hour or the 72-hour, do you have the right to put somebody in jail on the hope that you'll develop probable cause. That ain't done. New type of manslaughter. You might have seen it on Facebook. Let's say I'm just a guy and y'all are just people. They're just in the French Quarter, back when there used to be a bunch of people down there. Bad guy, for whatever reason, pulls out a pistol and shoots towards the crowd. Nobody would see it, thank goodness. One of the people who thought they were in danger and was in danger, carrying a concealed weapon, they took out his pistol and shot at the bad guy who started it. Missed him, but killed a registered nurse from Hamlin. And none of the statutes would exactly fit that acceptably, because normally the one who actually does the shooting and kills somebody needs to be in cahoots with the guy who started under the principal statute. And that would be this. Bad guy shoots at the crowd, somebody in the crowd shoots back, misses me, kills the nurse. I put it all in motion. I've got responsibility, a 40-year felony of manslaughter for starting that in motion. And that's a brand new statute. Person action, is that UPF or we do? I'm on the roll here. If I stop talking, I'll fall over probably. But anyway, on person action, snatching a person in person action. Look at the hole. There got to be something of value in the purse. Even if it's a brand new purse, and all you got in there is tissue paper or cardboard, you need to put that in the report. Because anything intimate, anything that you can touch has got some value. Remember in Section 2 of Title 14, anything of value, give it the broadest possible construction. If the shoplifting case is valued as it was valued that day that it was taken, but if there's anything in the purse, you need to put that in your report. And in a perfect world, you'll be asking to motion suppress. Officer, what was in the purse? I doubt you'll ever hear of that. You might be asked, what happened next? I suggest you say, Mr. Johnson grabbed the lady's purse with a cell phone in it, took off running, with something in it, whatever was in there, something. You don't have to list everything, but get at the motion to suppress, and at the preliminary examination, get in there, and at the trial, for goodness sakes, if there was something of value in the purse. That's a 2 to 20-year felony. If it's $800 Gucci purse, that's a misdemeanor. Probably theft. If it was on her shoulder, that's some force and violence that you take it off, it could be simple robbery, 0 to 7. But it's not purse snatching unless you can show that there was something of value in the purse. If you've got somebody who's been convicted before of battery of an officer, on repeat offenses, the penalties now are enhanced. They get higher and higher over the number of those charges they get. I'd rather you do this one here. This is a filthy case, filthy statute, and I feel better having a Baptist deacon explain. Go ahead, sir.
Thanks a lot.
I'm too pure for this.
Now I'm turning red. What can I say? Okay, basically, this is mingling harmful substances basically is a relative felony up to 2 years. That has been in the statutes. You know that under battery, you can not only intentional touching a person in a forceful way or intentionally touching a person without their consent, but also there's poisoning under battery. So you can have that under battery. But this is mingling harmful substances, like putting in something that was not intended to be there, like the guy going into Walmart and licking the ice cream, things of that nature, because it's
All right, who amongst us has not done that, Brady?
I hope the statute of limitations is run to it. But anyway, the thing about it is the new law is adulterating food product, and it's a relative felony.
5 years.
5 years. It came out this year because of a little case in New Orleans, and I always go and look up. It's like sexual abuse of an animal. Where did that come from? Out of New Orleans. Where did this come from? Out of the area around New Orleans. A lady baked those little pedophores, about 100 little pedophores for her class that were 7th grade, 3rd and 4th grade. Okay, I'm sorry, 3rd and 4th grade. They were young kids.
Well, except for the ones that play football, go ahead.
But they were young kids. So she bakes all these pedophores. Husband does the nasty on top of the pedophores. She goes to school and she Facebooks this, films those kids eating that. And basically the legislature passed this out of the legislature adulterating the food product. So
Okay,
that's
let
where the
me
case
say this way. Not number one, and it ain't number two. We ain't going any further than that. Okay? But they're believing.
And there's where it starts from.
Well, okay. Where were we? Thank you. Don't ever interrupt me again. Okay. Simple burglary. On any burglary, if they arm themselves or they're already armed, then it's a 3-year minimum. It used to be 0 to 12, now it's 3 years to 12. If they were armed when they did it or they armed themselves, here's a legal carrying of weapons. If the governor issues a mandatory evacuation order for South Louisiana, this current legislature passed a deal saying that when Daddy gets in the car, Mama and Huey, Dewey, and Louie, a lot of people scared, not knowing what's going on, don't know where they're going, are they going to be able to get gas? I want to keep my family safe. A lot of people without permits are going to put that pistol in their pocket. For 48 hours after the mandatory decree comes out, that doesn't apply to this crime right here. They got a free carry. So that means don't arrest them that 48 hours after this comes up. It also means you need to be thinking, because there's a whole lot more people with pistols in their pocket than they normally would be. And these people, a lot of them aren't bad people, but they're scared to death. And it's like, this came up because of all the evacuation orders that have come up this year. Quick case, State versus Miguel, there was a lawful traffic stop, and the driver admitted he'd been smoking marijuana, obviously a brain surgeon. And everybody there was some odor, and the officer saw a pill bottle in the door where they put your left hand, your left elbow. There was a broken pill bottle with the label torn off of it. None of the people in the car would claim it, so the officer opened it up. There was hydrocodone. It's a good search. Recent curtilage cases. This is good news. It starts off bad, but now it's good news, I think. Florida for Jardines. When Jardines came out in 2013 and Collins came out in 2018, it looked to us like they're making a big line trying to destroy Knock-and-Talk. But it looks like it's going to survive here. On the Florida for Jardines, they had heard some rumors about the guy in the house, got the drug officer, the canine officer and the canine, and they walked up to the door. Instructions given to the dog alerts to the air of the door. That was the sole probable cause utilized in the search warrant to search that house. The U.S. Supreme Court said, people can go up the front door, but they can't take the dog up there and get them to alert and then get a search warrant for that. They said this, they said the curtilage is just as protected as the home. Think about that a second. That's crazy. But they had that sentence in there. What's the most protected? Your person, then your home. Well, under that a little bit, trust me, is the curtilage. So Gene and I ignored that in 2013, thinking this is just a mistake. Then they said the same thing in 2018. They had a extended motorcycle up there in the driveway next to the house, and it was under a tarp. Everybody conceded, and this motorcycle had gone in excess of 145 miles an hour twice, eluding police. And the idiot puts it on Facebook at his girlfriend's house. And so one officer knew what house it was, so he went there, sees up the driveway what looks like exactly that extended motorcycle with a tarp on it, and it was parked the same place it was on Facebook. So he walks up the driveway, which I told him was fine. Girl Scout cannot go up there and knock on the door and sell cookies. 10 minutes for the best. And he checks the license plate, checks the VIN stolen. So he puts the tarp back on, waits till the guy gets home and arrested. The U.S. Supreme Court said that extended motorcycle could not have been any more protected by the Fourth Amendment had it been parked inside the home. What? Inside the home. Now something's come out that Gene and we've never seen before. There's Vermont versus Bovat. It would make it so much easier to remember if it was Borat. Nobody asked me, but anyways, Vermont versus Bovat. They had a ground they called
Deer jacket.
Deer jacket. Okay, that's what.
Killing a deer at night.
You did turn your machine on.
Right.
Well, okay. Y'all talk amongst yourselves.
Okay, the police got there and they spent about 15 minutes on the property. They went up to the garage and looked in the window to a garage and saw what looked like blood or fur, hair, something on the back end of the truck. After about 15 minutes, Mrs. Bovat went outside and asked what they were doing. They said they wanted her consent to go inside the garage and search. She said no. They left and used what they had observed by peeking in the window of the garage to get a search warrant. Came back, he ended up being prosecuted for deer jacking and was convicted. He tried to have that evidence suppressed, but he ended up being convicted. And he ended up in the U.S. Supreme Court, which did not get 4 votes to hear the case. So the conviction stood. But 3 of the justices issued something we've not ever seen before, a statement in which they discussed the concept of knock and talk and what was the acceptable way to do it.
Thank you, ma'am. Bottom line, in this statement, it says a really disparaging thing about knock and talk has been used as an excuse to meander all around the property. It's not really a knock and talk, it's just sort of an investigation in the yard. Officers all over the country going in the backyard. Here's what the bottom line they said. The home is protected. The curtilage is protected, much like the home. We can accept that. I agree with that. Here's somebody's person, here's the home, and here's the curtilage. But at least they pulled off these 3 from saying that the curtilage is just as protected as the home is not. You can do a knock and talk, but you need to go directly to the front door or the door that's normally used. Not try. Miss Smith, I'm off from Joe Blow with the Moser SO. Could I talk to you a minute? No, I'm busy right now. Okay, have a nice day. That's it. Go directly there and directly back. What you can't do is be meandering all around there. This is stunning to me, but you still got knock and talk, but you got to go directly to the door and directly back. And obviously, if you get let in with consent, now if you see stuff that's with criminality in it on your direct route to the door and your direct route back, I think you can clear the premises and hold it till you get a search warrant, but I wouldn't suggest you try to seize the deal. Even with the sweeps, the Louisiana Supreme Court said 6 months ago, if you pull in a sweep and you see something that's immediately apparent to be contraband, you can seize it. I think that's a bad idea. Or think of it like this. You got PC that there's criminality in this home. The home is really protected. So you want to get a search warrant. Now you got these gizmos where you get search warrants in 30 minutes instead of 4 hours. That's great. But while you wait, if there's some danger that's obvious about the scenario, the guy's a huge drug dealer or the guy's been violent to police before, you got the right to send in a couple of officers for a sweep. What's a sweep? You're looking for humans. Humans that may be hiding to try to potentially hurt officers, or humans that are trying to destroy the evidence. So those two officers can make a 3 or 4 or 5 minute sweep through the house. Look under the bed, look in the closet, look in the bathtub behind the shower curtain, only places where a person would be. Louisiana Supreme Court says if you're lawfully in there and you see something that's immediately apparent to be contraband, which they said is really just having PC, you can seize it. I think it's a bad idea for this reason. If you're in there pulling a sweep and you stop to see some evidence, the whole reason you're in there is to keep people safe. So you hadn't looked in the back bedroom yet, or you hadn't looked in this room here, you need to make sure that it's clear. And then after your sweep is over with, that's your excuse for being in the house. There's a third reason. I think if the two officers that go in on a sweep check things out, and one of them takes the time to tag it, bag it, all that kind of stuff, oh, there's some more. What's turned a 3 minute sweep is turned to a 30-minute search of the premises. And the search warrant hadn't been issued yet. You do the sweep, in our opinion, and you at most click, take a photo of the deal, and then when the search warrant comes, you can utilize that and get everything. If you've developed criminality during the sweep, if they got time to put that into the electronic application for search warrant, that's great. But my big deal through the years has been, I remember when I was assistant DA, and it's like, man, I thought I was great, really great. And I took a lot of time. About 3 weeks before jury trials, I'd get with the officers to make sure, usually go to the scene to try to get it straight in my mind. And I'm a guy that can't ever read a report and figure out what the north wall or the south end of the southeast part of the, I can't figure that out. I got to see it. Anyway, I got so good at it that I didn't go over things with Deputy Kemp and Deputy Batten, and pretty soon, one of them's recollection was one way about who got the drugs where, and the other one was the other way. Turned out Kemp was right. Batten, he wasn't lying, but he just was thinking about another case or made a mistake. I want one person to get all the evidence. One person. And if it's Officer Thomas that gets the evidence, who picks it up? That's where the chain starts right there. If you make sure that one person seizes all the evidence, then in that situation, on your return, what do you have? We got the heroin from the kitchen, who got it? Kemp. We got the marijuana from the living room, who got it? Kemp. We got the whatever, Kemp. Who takes it to the crime lab? Kemp. Now you're giving a present of a 5-minute chain of evidence to your assistant DA. And confusion inures to the benefit of the defendant in the jury trial, not to the benefit of law enforcement. It's 3:05, let's take 10 minutes, please. Y'all get fresh. We'll have Judge Jeff Cox and ADA Tammy Junk. Thank y'all. Why wouldn't you just use burglary of an inhabited dwelling or aggravated burglary? They're sort of different animals. If somebody is going to break in your tool shed behind your home and nobody lives there, and they steal something out of there, one of the things they have to steal is an old pistol, but it's still workable. That would be arming themselves. So instead of being 0 to 12, it's 3 to 12. That's up to the judge. You're not in again, you're not involved so much at the rear end of it. That didn't come out right. You're not involved with the sentencing part of it. But it's like the DA, you make the arrest, but the DA makes the charging decision. And it's like, you may make an arrest, like if it's a, aggravated burglary, it works like this. That's the 30-year felony. An unauthorized entry with intention to commit a theft or any felony therein into either an inhabited dwelling, that's where somebody lives occasionally. That doesn't mean anybody has to be home that night, or any structure where a human is present. It might be sleeping something off in my Oldsmobile that night. Somebody wants to get there and steal my 8-track, and that would be entering the structure where a humanoid is present. And then something else happens. Does the guy arm himself? Was he armed, or does he commit a battery? That's a 30-year felony. Almost never do you see prosecutors use a 30-year felony because it's hard to explain that the entry can either be into an inhabited dwelling, whether or not somebody's home, or it can be into any structure where a human's actually present. in every burglary, you gotta show that there was intent to steal or commit a felony therein. If they then go further and shove somebody or steal a pistol or had a pistol when they did it, that could be aggravated burglary. If you talk about just going in somebody's shed back there, and they had a pistol on them when they do that, and they had the intent to steal something from the shed, they happen to steal a pistol, well, now it's 3 to 12 instead of 0 to 12. Remember, you have something now that didn't exist 30 years ago, and that's if you can't prove exactly what the person was doing to break it in wanted to do. In other words, the crime of burglary is at the moment they made the unauthorized entry, you got to be able to prove they had the intent to commit any felony therein or make a theft. How do you prove it? The same way you prove whether or not they knew right from wrong. The moment after they made the entry, what they do? If they would go and put something in their pocket, they had the intent to steal. If they go and kill somebody or rape somebody, that can be the proof of the intent that they had going in there. But if Granny catches him the moment he makes the unauthorized entry, that's all you got. If you can't prove what their intention was, at least it's a 6-year felony, which is better than just 30 days for criminal trespass. But you write up the facts and you make the arrest, regardless of what you put in your report. The way the system works is the DA does the charging decision, and that's the way it's supposed to be. Don't need to get heartburn about that. I will say, I think all over the state we say the same thing. If you have an obvious felony, I think you make the arrest for the obvious felony, but don't get heartburn if the DA reduces it down to something else. That's the DA's job. And you know what? You may make an absolutely 100% perfect arrest with probable cause, say 51% likelihood of criminality, but a DA just doesn't think they can get it up to 95% to prove it in front of a jury. Even if they decline charges, they're going to probably be able to find a lesser charge to go to court with. But you may make a perfectly valid PC arrest, but it not be something that the DA, any DA, feels like they can get a conviction on. Jean's got some cases she's going to go over right now. Everybody talk amongst yourself. I ain't trying anything, Jean. There was a day.
Just give it.
50 years of marriage. See, you see the smile? Look. All right.
Okay, the cases we're going to talk about, the first two involve admissibility of confessions made during interrogation.
Did she interrupt me? Did anybody else think she interrupted me?
Okay. Mr. Barty in 2006 was convicted of attempted second-degree murder and sentenced to 40 years in prison. In front of witnesses, he stabbed his girlfriend 20 times, didn't succeed in killing her, took her car and abandoned the car a short time later. That happened in 2006. 10 years later, agency working a cold case found Barty's DNA under a murder victim who had been killed in 1998. They went and got Barty from prison, brought him to the agency, gave him his Miranda warnings, explained them to him, and he made a knowing waiver of his Miranda rights. A 7+ hour interrogation commenced. At about 36 minutes in, the officer said, "You are looking at the death penalty. But if you will confess to our satisfaction your part in this, and we can give the family of this woman who died in 1998 some closure, then we'll take the death penalty off the table." The lady was stabbed 30 times. He killed her, took her car, and abandoned it a short time later. The problem was Barty was 17 at the time of that murder and was not eligible for the death penalty. I mean, that wasn't even on the table. But during the course of the investigation, they kept hammering away that you're going to be subjected to the death penalty. At 48 minutes, Barty attempted to stop answering questions. He did that numerous times over the course of this long interrogation. He wept, he got real upset, very nervous, very scared. Every time he tried to pull back, they would come in and say, the prosecutor who's going to be handling this case has put so many people on death row. Here's a list of them. They wrote Marty's name at the bottom. They showed him pictures of the people on death row, talked about the conditions at death row at Angola and how horrific it was, and continued to hammer away. You've got to satisfy us and acknowledge your part in this murder. Did I tell you the lady was stabbed 30 times? Did I say that? Sorry. Okay. Anyway, after the conclusion of the interrogation, Marty had admitted his part, made a lot of incriminating statements. The next day he was transported back to prison. The corrections officer asked him if he was okay. He said yes. They talked to me about something that happened a long time ago. I really feel good having it off my chest. Now I can just go on and serve my time without worrying about that. The state wanted to use both of these statements in evidence. The Louisiana Supreme Court pointed out that in order to introduce a confession into evidence, the burden is on the state to show that that confession was free, voluntary, not made under threats, coercion, harassment, promises, inducements. Can't get it into evidence if that is the situation. The state could not meet that burden in the Marty case. And what the Supreme Court said was, Marty made a knowing waiver of his Miranda rights. At 48 minutes, he tried to stop questioning. The officers ignored that. Nothing he said after the 48-minute mark can be used against him in court. As to the statement to the corrections officer, they said the lower court has not ruled on whether that statement was free and voluntary, and they sent it back to the lower court for that determination. A similar, well, not similar, but another case, State versus Christopher Alexander.
1 second, I'm sorry, please. Part of what they threatened the Barty with was, they said this prosecutor is a bad MF, and they weren't talking about mandatory felony. Thank you. Go ahead.
That was so unnecessary, but you got the message, okay? They used a lot of threats and pressure. And Christopher Alexander, during his interrogation, the officer said, look, nothing we talk about here is going to leave the four walls of this room. So whatever, you don't have to worry about it. Just go ahead and tell me it's just between us. Later in the interrogation, he said, you need to get out there and apologize to your mother for what you did. And you go out there right now and apologize to your mother. And the officer told the mother, this is all just going to stay right here. Nobody else needs to know about what we're talking about. Well, that was incorrect information because the purpose was to get incriminating statements to use in court. And although, like Marty, Christopher Alexander had knowingly waived his Miranda rights, the court said that the misinformation by the officer destroyed the validity of his Miranda waivers, and those statements could not be used. Now, in the Schistler case, the Louisiana Supreme Court told officers how you can get into somebody's home if you don't have consent and you don't have a search warrant. Schistler was arrested right near his house, and the officers, after they made the arrest, went into his house and found other drugs and guns. Schistler wanted that evidence suppressed. And the court said, officer, you can go into a home without consent and without arrest warrant, but you have to have probable cause to make an arrest or perform a search, and you have to have an emergency circumstance. Somebody about to get away, evidence about to be destroyed, a situation going on where the law officers or other people are in danger of what's going on in the house. You can also do a protective sweep where you go in to make sure there's nobody in there to destroy the evidence or run off, but those are the circumstances. Unless you have one of those emergency situations, plus probable cause, you cannot legally go into that house. In this case, they said, well, look, there were these surveillance cameras on the house. So we thought, that made it an emergency, the state argued. The Louisiana Supreme Court said, no, surveillance cameras do not constitute an emergency. So that evidence was suppressed. Another case where the Louisiana Supreme Court instructed law officers was sort of an unusual case and a complicated investigation of a heroin dealer in New Orleans. And the officers were working 2 consent searches of 2 different properties to which Donovan Alexander was connected, and they had him in custody. During all this, lots of officers, lots of moving parts. A lawyer showed up and said, I'm Donovan Alexander's cousin. I have represented him on several occasions. Here's my documentation to show that I'm a licensed attorney. I do not want my client questioned. I want to speak with my client now. Well, it's unclear from the record exactly what went wrong, but a lot did, and the attorney did not get to speak to Donovan Alexander. I think it was even the next day before he saw the lawyer. And the Louisiana Supreme Court said, if you have someone in custody or in the middle of an investigation and somebody shows up who documents that they are an attorney who represents that person, A, you have to stop and talk to the lawyer. B, you have to let the person in custody know that there's a lawyer there who's wanting to talk to the person you're holding. And if the person wants to talk to the lawyer, and I think the chances are very high that the person will, you have to provide them a place where they can consult in private. It's an unusual situation. I don't know how many times a lawyer shows up while you're in the middle of doing something, but it happened here, and that's the way it has to be treated, Armin.
Well, the stop has to be immediate on the interrogation. We don't think the stop needs to be immediate if you're doing a scientific test. If you have some evidence that's about to dissipate, we think you can complete that investigation. We're not certain, but it's like if you've already observed the guy 20 minutes, gone through the rights about a breath test, and you're just starting a breath test, if you get the notice that his cousin Vinny, his para-lawyer, is out here, we don't think you have to stop right then. Well, you just mark when you got that information, continue the test, and then comply with all these things here that they're talking about. Okay. Are you with this? Okay. Flight for officer.
You've already talked about.
Yeah, but this is what I want right here.
Okay. Harmon has already talked to you about flight from an officer where somebody runs off when you're trying to arrest him.
That's resistance, that's the type of resistance.
Thank you.
Okay.
Very good. Okay, on page 101 and 102 in your book is the statute about flight from an officer, and this involves a motor vehicle running from a marked unit with lights and siren. If the guy just won't pull over, that's a misdemeanor. If the guy driving or the woman driving does any of 6 things that are listed on the top of page 102, the person does 2 of those things on that list, leaves the roadway, speeds 25 plus over the speed limit, has a collision, fails to obey a stop or yield sign, fails to obey a traffic signal, travels against traffic. A person can do 2 different things on that list, or in a recent case of State v. Turner, the Supreme Court said, if somebody runs 2 stop signs, those are 2 separate instances where human life could be in danger if somebody was coming the other way. So that too counts. You could get it up to a felony grade, the driver doing 2 of these things on the list, or doing 1 of the things 2 or more times. Okay, the next case is Kansas versus Glover. officer was patrolling, decided to run a plate on the car. It came back that the owner of the vehicle had a revoked license, was a man in his 60s. It goes all the way to the U.S. Supreme Court, which said, based on the objective information this officer had, he used or she used her common sense and made a decision to make a reasonable suspicion traffic stop. That is a very brief traffic stop where it's usually a yes or no. Is the light working or is it not working? What this officer did was stop. It turned out that the owner was Mr. Glover, who did have a revoked license, and he was prosecuted for that. And the way the Supreme Court handled it was they said, nothing took place that destroyed that officer's reasonable suspicion. And the example that they gave was, if the officer learned that the owner with a revoked license was a man in his 60s and a female in her 20s was driving the car, that would have ended the reasonable suspicion, and stopping that woman would have been an unlawful stop because there was no reasonable suspicion that that driver had a revoked license.
A lot of people,
Here.
a lot of people think that PC is required on a traffic stop. It's really not. But a reasonable suspicion traffic stop is a brief motherfucker.
Sorry.
Thank you, darling. As I was saying, the reasonable suspicion traffic stops, like as Gene says, are binary issues usually. Was a headlight out? Was a plate missing? Just one little quick thing. But reasonable suspicion stops are lawful. Some agencies have policies, they don't want their officers making reasonable suspicion traffic stops. They want PC. It ain't real hard this day and age. If you're not sure you already have PC, follow the guy a little ways and you'll probably see a traffic infraction. You observe an infraction, the stop's good. I would say a reasonable suspicion traffic stop gives you 3 or 4 minutes. A PC traffic stop, they gives you 12 or 15 minutes. But normally, it's up to an agency whether they want their officers doing a reasonable suspicion stop. But usually in this situation, it was valid, and the fact that the demographics match were good. You need this?
Yeah.
Did you say no, sir? Or no? I'm kidding.
No.
Okay. All right. I'm just checking, sweetheart. All right. We've already been over this deal here about the names of the guest passenger. You also need a policy about, inventories. Dwayne, y'all need a policy saying that when officers of both your SO or inventory motor vehicles, they need to inventory the contents of closed containers. That's all it needs to be if you want to do that. Otherwise, you're not going to get into the stuff that's inventoried in the suitcase. And Judge Cox, and we were teaching the agency in Baton Rouge, it's an excellent agency, and they didn't have that in their policy. This is 30 years old, and the few cases that have been up about this, there's no give whatsoever. So, and y'all probably already got a prohibition on sales of motor vehicle lights with a blue glow for the guy who wants to play like he's a police officer. Here's Judge Cox. You got that.
Okay. We'll cover this real quickly. We're going to talk about theft, show-ups, lineups, and implied consent. Basically, basic theft. If you have a theft, it's just basic. Go under basic theft. They have other statutes that are felonies out there, but if you don't want to do those other statutes, you can go under basic theft. And you know the amounts that you have to be able to charge and what those, you're not really worried about what the amount of time is going to be, but you know that if it's like between 1,000 and 5,000, it's a relative felony up to 5 years. If anything is over $25,000, then you know it's a mandatory felony, 5 to 20 years. There are other statutes out there. There's several thefts that are always felonies. For example, theft of livestock, theft of timber, and theft of firearms. If you get out there and you've got somebody that's stealing timber and you don't know what the value of the timber is and you can't charge basic theft, you can charge theft of timber and arrest them and then come back and let the DA charge whatever they want to, but you can get them off the street with theft of timber. Now let me just put it this way. If you find that somebody's stealing alligators, let the alligator take care of the problem and arrest what's left over, okay? So, Basically, show-ups, you have a show-up that's not as strong as a lineup. That's where you're bringing back the defendant to the victim. You have 2 hours. It's a one-on-one identification. It's not as strong as a lineup, but you have to do this while the memories are fresh. There's a case out of the state of Louisiana that was done last year, State versus Butler, and says that if you show one photo to a victim 22 years later, that is unduly suggestive. So that case just came out last year. Lineups, you got the blind and blinded lineup. You need to read this on page 166. It tells you how you are to do the blind and the blinded lineup. You can do this either with live lineups or you can do it with photographic lineups. Most of the time, I would say it's going to be done with photographic lineups. If a person, you've got to be well aware of Photoshop. So basically, if the person has a scar across their face or a tattoo on their face, you have to put that on everybody's face, okay? That means that you have to Photoshop that on each person's face when you do this. Blind lineup is conducted by 2 persons. The blinded lineup is conducted by 1 person, but you can read how those are conducted. The main thing is the administrator of the lineup in the blind lineup does not know anything about the case. So basically they know nothing about the case. In the blinded lineup, there has to be a partition between the 2 people, between the victim and the person that's administrating the investigator administrator. And this is what has to be said. Basically, if it's a blind lineup and you're handing it to another person, you have to say the person that committed this crime may or may not be in these photographs. If it is a blinded lineup and the investigator is doing it by themselves, he or she has to say the person, and has to say this to the victim of course is behind the partition, the person who committed this crime may or may not be in these lineups. You need to write good reports on this. You need to videotape it if you can videotape it, because there will be questions. The other thing is, in 2018, this policy was passed. Every even-numbered year, this policy is supposed to be reviewed by your agency and updated. Tammy had a case in another parish that she was prosecuting, and they were doing a blind lineup. The officer handed the pictures to a patrol officer. The patrol officer went in and handled the lineup, basically came back out, but didn't write a report. Got on the stand, and basically what happened was the officer testified, and then the defense attorney held up the book from the sheriff's department and said, would it surprise you to know that you're supposed to do this, this, and this? And he said, yeah, that would surprise me. So you need to go and make sure that you read this agency's policy on the blind and blinded lineup before you go to the court, because it's very, very important. Timms versus Indiana. Timms versus Indiana, Mr. Timms was what I like to call a recreational pharmacist. He was passing out cocaine on the street, okay? So basically from that standpoint, he's selling cocaine, he gets caught. Mr. Timms got an inheritance from his daddy, and basically bought a Range Rover to ply his trade with. So he's out there selling cocaine. Basically he gets popped, they give him a $10,000 fine, the DA's office seized his vehicle. And what happened was that Mr. Timms didn't like that. He went to the Supreme Court, the vehicle was worth 5 times more than what the fine was, and the Supreme Court said that excessive fines and forfeitures are prohibited by the 8th Amendment, and had to return the vehicle back to Mr. Timms under that situation. That has limited, of course, our law enforcement agencies from being able to get fines and court costs and vehicles. Okay, new statute. Felony sexual battery is not the new statute. Touching the anus or genitals of the victim, you can do that above the clothing. That's a relative felony up to 10 years. The new statute is the misdemeanor sexual battery. Touching the breast or buttocks of a victim, that is a misdemeanor up to 6 months. Second-degree sexual battery is felony sexual battery. The first one, touching anus or genitals of a victim, plus serious bodily injury. And you remember 14.2 defines serious bodily injury. And that is a relative felony up to 15 years. Implied consent. This is very, very important. This is operation of motor vehicle on the public highways, whether or not the driver has a valid driver's license. Basically, under implied consent, we're going to talk about that in a minute, but you remember Birchfield versus North Dakota came out in 2016. Birchfield versus North Dakota said that you either had to have a search warrant or consent to get a blood test, and that you could not threaten prosecution under implied consent laws because to get a blood test. Why was that? A blood test involves what? A needle, and a needle gets blood, and blood leaves behind what? DNA, right? What's the most protected thing that we talk about is our person, correct? So you have to have a search warrant or consent to be able to get the blood according to Birchfield. Now you can still threaten prosecution under implied consent laws to get a breath test. Everybody has to breathe, and it doesn't leave behind any DNA. But the problem is, I haven't seen anybody be able to take a straw in somebody's mouth and make them breathe through the straw yet. So they don't necessarily have to give you a breath test. Mitchell versus Wisconsin was a case. I love these words out of this case because it just gives us all great comfort. Mr. Mitchell was drinking on a cold winter's night in Wisconsin, and basically he had a little too much to drink. Must have been drinking antifreeze, because when the officers were called, they were told that Mr. Mitchell had left the premises. They found him wandering around the lake, and the officers had a field breath test. They gave the field breath test to him, and he really had some blood in his alcohol at 0.23%. So they put him in the back of the vehicle. They're taking him to the office to get an official breath test. Mr. Mitchell passes out. The officer wheeled him into the hospital, drove in the hospital, got a wheelchair, wheeled him into a hospital room, and looked at Mr. Mitchell and said, "Mr. Mitchell, you have the right to remain silent. You have the right to an attorney." He read him all of his rights and basically told him that he could refuse a blood test. Mr. Mitchell did what was natural. He just sat there and snored. Okay, so the officer told the nurse, "Take the blood test." He still had blood in the alcohol at 0.21%. He was convicted of DWI, went to the United States Supreme Court, and they gave us these comforting words. When a person is unconscious, we will almost always allow a blood draw. So basically, after reading them the rights, if they remain unconscious, you can almost always count on Mitchell versus Wisconsin and take blood from somebody. State versus Michael was a case out of South Louisiana. Mr. Michael caused an accident at one location. He left the scene. The officers caught up with him at another location. Because of some exigent circumstances that were happening, the officers were able to get a blood draw from Mr. Michael, and the Supreme Court of Louisiana allowed that. Now, implied consent, 32681. 32681 used to say that if there was a death at the scene, that under implied consent you could withdraw blood. Last year, thanks to Judge Drew, Ms. Drew, and to Tammy and I to some degree, 32681 was amended, and also Ms. Grantham. Y'all remember this case that happened up on Benton Road, right up here, and it was a tragic situation. Little Katie Bug was injured, okay? She did not die at the scene. The officers who were there did a fantastic job of everything, of noting everything and doing everything and trying to see if there was any impairment. There was no impairment that was noted. Because there was no fatality, they could not do a chemical test at that time. But there were suspected serious injuries at the scene. You need to look at page 124 through 126. 32681 was amended to say, under that, suspected serious injuries. If you have these, severe lacerations, broken extremities, crushing injuries, significant injuries, skull, abdomen, or chest, paralysis, unconscious when leaving the scene, and burns, that basically you can take a chemical test, okay? That you have the right. If somebody dies at the scene or somebody has suspected serious injuries, you can take the chemical test. And 32681F also applies that the law officer does not have any liability for doing that test, okay? So you cannot be sued. You have qualified immunity under all of these laws to be able to take that test. And this came into place because basically there were suspected serious injuries, Out, despite all the officers' best efforts, 2 days later, they found methamphetamines in the truck. So you have to remember that implied consent applies. Implied consent 32681 if there is a death or serious bodily injury, serious suspected injury that you can get the chemical test. Please write good reports. I'll say that real quick. Knowledge, training, experience in every report that protects you. It helps me to be able to do my job at the Second Circuit. As you know, I used to be district judge here. I knew every one of y'all when you came to testify. I can tell you there's 8 other people over there that don't have any clue who you are. 7 other people in New Orleans. We do read the reports, and I can guarantee you, if it's knowledge, training, experience in there, it helps. Thank y'all, and I appreciate y'all very much.
Go ahead, Tammy.
I'm going. Okay, raise the age and effective July 1, 2020. We have to put 17-year-olds in juvenile detention. It does not matter what kind of crime they commit. It could be a homicide, armed robbery, rape, it doesn't matter. At least for that first night, you need to take them to juvenile detention. There are 2 ways that the DA's office can transfer them to adult court on certain crimes. That's either by an indictment by a grand jury, or they can do a 72-hour hearing, which is normally what you do in a juvenile detention situation, and then the judge can sign the paperwork to transfer them to adult court. But when you arrest a 17-year-old now, it does not matter what the crime was, you have to take them to juvenile detention, okay? You cannot take them to what I call big boy jail. Okay, domestic violence, these situations to me are the most serious that y'all probably deal with on a daily basis. And battery of a dating partner and domestic abuse battery initially are misdemeanors. They do have felony enhancements, and those are listed in your book starting on page 38. All of the battery of a dating partner and domestic abuse battery have the same felony enhancements, like child endangerment, the person being pregnant. Those are all available to you, but the initial ones are misdemeanors. So the key for y'all is to find out what the relationship is when you get to the scene. Have your cameras on. Usually what happens is, and I'm just going to use a female as a victim because that's 95% of our cases, females coming to the unit hollering and screaming at you, take him to jail, take him to jail, take him to jail, he's trying to kill me, and then the next morning, where's she at? She's either at the jail trying to bond him out, or she's at the DA's office trying to sign a drop charge slip, right? So that evidence that y'all have, either in your report if you don't have cameras, or if you have your cameras and you have that, it's great evidence for your prosecutor. I normally have the video ready if she's in my office and she's telling me, I didn't call the police, Miss Tammy, I don't know who called them, I didn't call them. And I told them when they got there, don't take him to jail, he didn't do anything. Really, that's what you said? And I pushed play and let her hear herself. Normally what has happened is his mama has been blowing up her phone all night, telling her, how many times have y'all heard this? He's got a good job, and he doesn't need to go to jail. He doesn't need to stay in jail, he's got a good job. So I let him sign a drop charge slip, and we go on our way, I still prosecute him. The key is to find out the relationship. If they're just what I call Ringo talking, it's battery of a dating partner. If they're living together, either they're husband and wife or they're living together as husband and wife, then it's domestic abuse battery. And there are so many people that fall under domestic abuse battery or domestic abuse situations now. Family member now means spouses, former spouses, parents, children, step-parents, stepchildren, foster parents, foster children. In August the 1st of 2020, they added ascendants and descendants. They also added the parent or foster parent of any child or foster child of the offender. Y'all got it? It's very complicated. When I get calls in the middle of the night from my guys that's got a complicated relationship, it's not just husband and wife, I have to get the book out and read it 3 times after I wake up to make sure that it falls under it. But the majority of situations that y'all are probably gonna deal with when you've got a family situation, it's gonna fall under domestic. A household member, which is your normal husband and wife, is any person presently or formerly living in the same residence with the offender who's been involved in a sexual or intimate relationship. Now, this can be if they've ever lived together. Used to, for those of you old enough to remember this, it was 5 years. It had to be within the last 5 years. They could have lived together 20 years ago and split up, and somehow they got back together, or they just saw each other somewhere and get in a fight. It falls under domestic abuse battery. I also included if any child presently or formerly living in the residence, or any child of the offender, regardless of where the child resides. So again, y'all can see a lot of people fall under domestic. If you can go with domestic, go with domestic. And the reason for that is the penalties are a little higher on the front end, and on the back end, as DAs, we can get their firearms if they're convicted of a domestic abuse battery or of a battery to dating partner second offense, but mainly domestic abuse battery. We can get their firearms. It's something we have to do in court. It's a process we have to do. They have to bring them to the sheriff's office, turn them over, and there's also penalties of, in 1495.10, if they're convicted of a domestic and they're in possession of a firearm, it's a felony. Sometimes when you run their CH, and you may be working the night shift, and you run their CH, and you see they have an arrest for domestic, but you don't have a disposition, you may have to wait and get with your DA's office the next day and find out, do they have a conviction? I just had that happen the other day. Our guys couldn't tell from the CH that he had been convicted of it. Once they found that out, they just went and got a warrant for him and arrested him for possession of firearm by persons convicted of domestic abuse battery, okay? Winslow hearings are no longer mandatory. The class we taught last night of Bossier guys, they said that sometimes y'all are doing them, sometimes not. It's up to the judge whether he wants to have it or not, and he can just normally call the prosecutor and find out if there's been a history or if he thinks he needs to have a Winslow hearing, but we don't have to have them anymore. And the domestic violence firearm transfer stuff is on page 178 to 184. Again, it's really an administrative thing between the DA's office and somebody in the sheriff's office and the judge. You can serve her with her certified copy at the scene. In other words, what happens normally in my parish is our DART advocate, which is kind of like y'all's Family Justice Center people, our DART advocate takes a victim on Friday afternoon about 3:30 to get a protective order or a restraining order. Judge signs it, goes down to the sheriff's office. The civil office may process it, but they may not. Even if they do process it, may get in a patrol guy's hands, and they may don't have a call and don't get it served immediately. Well, 8 o'clock that night, what's going to happen? You get a 911 call, woman screaming, hollering, I got a restraining order, I got a restraining order. He's in the background hollering, I ain't got served with a restraining order. What are you talking about? So y'all show up, she's waving it around, and it should be certified. Ask her for it. Get it from her, serve him with it. That's valid service. You have to put it in your report that that's how you served him, but it's valid service. Give him a chance to go. Don't just serve him and then say, put your hands behind your back. Give him a chance to go. Judge Drew says 5 hippopotamuses, right?
Used to be Mississippi, but I moved to 5 syllables.
Right. 5 hippopotamuses. Give him a chance to go. If he doesn't go, or if he starts giving you lip or whatever, and you know that he's not going to go, then you can hook him up for a violation of protective order. And if he starts acting a fool, you may get resisting officer or some other charge, but at the least, you've got violation of protective order. But you can serve him at the scene with the certified copy, put it in your report that that's how you served him, and have your cameras on. Make sure you have your cameras on. Can she violate her own order? No. As much as y'all want to arrest her because she has called over and over again, and you get there and he holds up his phone and says, Mr. Officer Man, she called me and told me to come over here, or he's got text messages, which is even better. She texted me and told me to come over here. I know it's frustrating, because I have to deal with them too, the victims too. I know it's frustrating. She cannot violate her restraining order. You have to put him in handcuffs because he's in violation of protective order again. Now, when it gets to the DA's office, and you put that in your report that he showed you text messages or phone calls or whatever, yeah, the DA's office may decide that they either don't want to prosecute him or they want to let us, tell the judge we want to lower his bond, whatever the situation may be. But what happens is she runs out of money, she can't feed the kids, she calls him and says, hey baby, come home, we love you. And he just goes on back and thinks that it's okay because she called him. She can't dismiss that protective order. A judge is the only person that can dismiss that protective order. What we try to tell our victims is if you change your mind and you want him back home, you need to contact our DART advocate or you need to contact an attorney and they need to get you back in front of the judge so that you can have that restraining order or protective order dismissed. So it's very important for y'all to know that. She can't violate her own order. These pages are some of the most important pages in the book, if you ask me. 184 through 187 is your duties when it comes to domestic violence. We've talked about qualified immunity today. If you do not do what is on these pages, you lose your qualified immunity. You have to arrest if there's probable cause for a felony. You may arrest if there's probable cause for a misdemeanor. You assist her in her medical needs and you notify her of her rights. You have to write a report on all domestic violence calls, whether you make an arrest or not. I'm going to repeat that. You have to write a report on all domestic violence calls, whether you make an arrest or not. If you get there and you just do not see probable cause to make an arrest, that's fine. It's your call, but you have to go back to the substation or your sheriff's department or the police department and write a report. It's all got to be documented. Because eventually, it's probably going to end up that you got probable cause to arrest somebody for something. And as a prosecutor, I would love to have a stack of reports that show that you've been there to that house, but you just couldn't find probable cause at one particular time. So just make sure that you write a report. All of these statutes, I didn't forget, all of these statutes apply to same-sex couples, okay? I always forget that. All of these statutes apply. Now that was not necessary. Yeah, I'm gonna be like Miss Jean, please don't encourage him by laughing at him.
There's some people from Ringwood here, I want to make sure that.
Oh, they know. They know.
Oh, they do.
Okay, they all apply to same-sex couples. A lot of times we deal with that when we're talking about college campuses and stuff, some of that stuff happens there, but same-sex couples, it all applies. That's it.
Tammy Junk, Jeff Cox, Gene Drew, I'm Harmer Drew, that was Edward Bird. Thank y'all. Be safe, hope to see you next year. Thank y'all.